Hello, my name is Len. I'm your host of Targeted Justice v. Garland, a podcast about an extraordinary lawsuit. Today we have a very special episode because we have an update from the Fifth Circuit where our main lawsuit is currently in. With me today, as always, attorney for the plaintiffs, a remarkable legal mind, Anna Toledo. Please say hi to our viewers.
Hi, Len. Good morning. Hi, Richard. Thank you for having this because it's really important to keep everybody updated that sometimes what seems to be is not necessarily it, and we're never going to stop fighting. So let's get on with it.
Very good introduction. Thank you. And for this special occasion with us today, a board member of Targeted Justice, legendary Richard Lighthouse. Good morning, Richard.
Good morning, Len. Thank you for having me on.
My pleasure. Our pleasure. So, what are we going to talk today about is the petition for en banc rehearing, which was denied in the Fifth Circuit. It happened on April 24th, so it's really fresh, and we could not wait to update you on it. If you remember, maybe like 3 episodes ago, we were talking about the petition for en banc rehearing, and now we received a document from the court that it was denied. It was a very simple document. Basically, it was filed by the Fifth Circuit clerk before Dennis, Elrod, and Wilson. Those are the 3 judges that brought an opinion, which was not really an opinion, it was a summary calendar, but they agreed with the district court. Here's what the clerk said. Treating the petition for rehearing en banc as a petition for panel rehearing, the petition for panel rehearing is denied. Very consistent language. But here's the reason. Because no member of the panel of judge in regular active service requested that the court be polled on rehearing en banc. The petition for rehearing en banc is denied. So my question to Anna is, you filed it so it would reach every judge in the Fifth Circuit. But here's the clerk telling you that because none of the 3 judges that initially reviewed it requested en banc, the petition is denied. Is that something consistent with the rules, or is this something unusual? Because I'm not familiar with the Rule 35.
Well, that's one of the things that I'm going to be asking the court for a clarification because it says, yeah, that's true. They can the panel that decided that issued the opinion, the unpublished opinion that does not constitute precedent, they can check and decide if they're going to do a panel rehearing. But if not, here's what the internal operating procedures say, that they have to refer it to the chief judge, and if the chief judge circulates it, and then everybody gets polled on, all the active members get polled on it. So I want to know if, in fact, all active judges voted against it, and that's one of the issues are going to be submitting for clarification, because there is something that just, let me tell you, when an attorney signs a document, there is something called Rule 11, which is that to your best, what you put in there, what you wrote in there, to the best professional judgment is correct and accurate, because you're not supposed to file anything frivolous, and you're not supposed to waste the court's time. And every single document I have filed constitutes a certification that what I am submitting to the court is not only grounded on fact and law, but it's not set forth to delay anything or to obtain a result that is not consistent with precedent. So this en banc petition is, they take that very, very seriously. And as you can see, there is no expression about, it's meritless. or it has no grounds, or it's fantastical. So that's why I'm going to be submitting a motion requesting a clarification about it.
So this is your step, filing a motion for clarification whether it reached every judge in the Fifth Circuit. I know that you prepared some documents that you wanted to share. You want to make some points about this process and decision.
Please. The reason I want to share it is this, because a lot of targeted individuals, they don't realize the work and the incredible amount of work and effort that goes into this. Just because our case got dismissed does not mean it didn't have merit, because it was so thoroughly documented and the pleadings were, most of them, so uncontroverted, and they met the threshold that federal courts have. They even went beyond the threshold of Rule 8. Okay, so since the pleadings in the complaint not only met, but I think surpassed the requirements, the pleading requirements of Rule 8 of civil procedure, in this case, Rule 35 is the one that controls the en banc petition. And there's two criteria. One, the en banc court should issue it because it goes against established precedent by the Supreme Court or the Fifth Circuit. And the second prong, it's either or, but we have both, that it presents a matter of exceptional importance. So in the first one, we talk about, these are all these cases. For example, one Supreme Court that says, and Fifth Circuit, the complaint has to be assumed it's true, okay, in all of its parts, because it was on a motion to dismiss. The other one that says Bell Atlantic versus Twomey, that says just the plausibility, the pleadings have to be plausible. That doesn't mean they have to be probable. The court cannot say, I don't believe it. No, if they are plausible, particularly since we put a lot of allegations regarding the warrantless assessments, the breakings, how Richard has the evidence of the deputy sheriffs telling him he was on a terrorist list, and he's never stopped when he travels. So there you have a lot. So these are cases that Missouri versus Biden, which is one that the Fifth Circuit adjudicated, that we discussed previously here, that says agency action cannot be beyond its authority. And that's exactly what we're saying here. The FBI, Ray, and Cable, but now it's Glasheen, right? Well, they are acting beyond the authority that Homeland Security Presidential Directive 6 gave them, because they are putting innocent people on a terrorist database. If that is not arbitrary and capricious agency action, nothing is. Okay, let's go to the next one. So, we have the same panel, the same court saying in Missouri v. Biden, you cannot go and interfere with the free speech of people, but they're not offended by the fact that innocent Americans are being placed on a terrorist database. I don't believe that. I think that maybe they didn't see the petition. That's what I'm going to be asking for. This is the second one, right? So these are other precedents from the Fifth Circuit that are relevant to this case. For example, it is not necessary for all plaintiffs to demonstrate standing. Just with Richard's evidence and Karen Stewart's evidence that they were told under circumstantial evidence that they were on the TSDB, that is sufficient to grant standing to the other ones. For example, it's not fantastical when a man lying down on the ground in extreme excruciating pain is being told by a deputy sheriff that he cannot let the ambulance in because he was told that a suspected terrorist lived in the house. That is not fantastical. I'm sorry, particularly when Lighthouse does not have voice to call. So these are precedents that I believe constitute legal error, because, for example, the panel's decision refused to look at the arguments of our appeal and then decided to confirm the fantastical conclusion by Judge Rosenthal based on reviewing the preliminary injunction request that we didn't request, that we didn't brief on. So the court could not go over an issue that was not briefed on appeal. That's just very strange that they chose to adjudicate a matter that was not before the court. And that's, I think that, targeted individuals that are, I know they're all looking to this because we all want to be free, right? It's not that the correct arguments were not set forth. It's that there have been legal mistakes made along the way, and we're going to fight them all the way to the Supreme Court now, which is where we have to go. Can you show the third one? The third one is about the matter of exceptional importance. What I was telling the court is, the exceptional importance that this case has is this is the first case to challenge before any court of the United States that unchecked ultra vires, that means beyond their authority, executive branch practice in excess of their legal authority by FBI of labeling innocent Americans, such as plaintiffs, as suspected terrorists without reasonable suspicion for it, pursuant to a secret criteria, without giving them due process, which is the FREAKRA case, okay, that says, no, if you're put into this terrorist database, due process requires they tell you why they put you in there. Without due process and an opportunity to controvert the permanent inclusion into unauthorized categories of the terrorist screen-based database. This has not one, this has like 5 different exceptional circumstances under which a court of appeals should have granted, should review, the panel should review this. And the second one is that this case is the first one to present the government defamation that comes along being placed legally, secretly, without reasonable suspicion on a terrorist database. So what I'm just telling, everybody out there should know, it's not for lack of merits that we are not being heard.
I agree with you. To me, it's for the lack of courage, because these items, these questions that you're asking for the first time, it takes courage from the judges to really pay attention to what's going on instead of sweeping it under the rug. It's a matter of perspective. This is the first legal case regarding targeted individuals in this new framework, in the TSDB framework that reached Court of Appeals. And it will be the first one to reach the Supreme Court. So to me, it's a win-win. Even though from a different perspective, from an outsider who is not really following all the intricacy of the case, they could say, well, targeted justice filed and it was denied. They filed an appeal and it was denied. So 2 losers. No, it's not a loss. This is the first time that we are going to break that glass ceiling, and you can't break the glass ceiling on the first time. This is a first hit. This is the first time it will reach the Supreme Court. Richard, do you have any questions for Anna? I'm really interested in hearing your perspective.
Thanks, Len. Yeah, it's apparent that we had evidence that at least one of the judges had a conflict of interest and should have recused himself. So I'm a little concerned that the court's not paying attention to the procedures, because that's a conflict of interest and a recusal at the Fifth Circuit level is a huge issue, and for them to just gloss over it is both disappointing and unfortunate. In fact, it's kind of hard to believe. But I'm hoping that Attorney Anna can provide a little bit more clarification on some of these court procedures, because I agree with you. This is simply the first case. Targeted justice has repeatedly said that we're not just pursuing one case. We've got lots of things on the back burner, and we want TIs to be aware that things in the works, and we are pedaling as fast as we can. Okay. Thank you.
I want to add to that. I really urge everybody in the tab in the targeted justice, and as soon as I find my motion for clarification, I'm going to put it there. In the targeted justice website, there's a tab that says lawsuits, but you have to go down in that tab and then click on TJB Garland, and that's where the documents are, because people were writing to me that they couldn't see the documents. So yes, you're going to be able to see it there. And I think that, people, it's very easy for people to criticize, and they don't know how much work, how much effort, how much expense goes into this litigation, even though, it's the expenses are, for research, for mailing, for internet, for everything that goes into working and being able to do this kind of work. That's number one. And number two is that we also have another litigation going, as you know, and the FBI is looking for ways to say that the discovery rules don't apply to them. And so they're going to come up with, they already anticipated, told me that they're going to be opposing any kind of discovery because they're above the law, you see. So we're doing that. And I am very hopeful, because here's the thing. You have to look at 1 year ago, nobody was talking about this. Today, not just targeted justice is talking about it. It's targeted journalists like Laura Loomer, like James O'Keefe. I mean, there's like even Salty Cracker. I mean, there are people that are well known that are acknowledging they are targeted. So does Mike Adams. He says our business is targeted. He said to me in the interview. Okay, so this is second-class citizenship within America, in plain sight, an open secret, and it is time for the courts to carry out their role, because it's the ones carrying out the abuse are Congress authorizing FISA and allowing even the electrician that comes to your house now spy on you. Then you have the executive branch with the FBI with warrantless surveillance, and also their infraguard and citizen court minions going around chasing and surveying people that do not meet reasonable suspicion criteria to be on any terrorist list. If that is not illegal, I don't know what is. Okay, so we are relying on the courts to carry out the balance of power here, the separation of powers, and to protect the constitutional rights of people. And I still hope that the courts will come through and protect our rights. I still hope that.
Thank you, Anna. I have another question for you. When I realized that the en banc petition was denied, and you told me that you were going to file a motion for clarification, so the next step is the Supreme Court, without a doubt. I have a question for you. Can you think of any other precedent, or perhaps multiple precedents, when a case was denied on the district court level and then denied at the U.S. appeal level, and then taken up by the Supreme Court? Because we know that the Supreme Court chooses their cases. They are not obligated to take cases for review.
You're correct. The Supreme Court review is discretionary. And there's Brandenburg versus Ohio is one case which lost at a district court level, at a court of appeals level. And that's like one really important case in First Amendment law. And the Supreme Court reversed. Okay. I'm sure there's like many of these examples, because it's, the underdog fighting and that finally gets somewhere. But I think that we are at a place in history. We have the mislabeled as a threat situation with Gary Peters' committee. We have FBI versus FICRE. That was favorable to Mr. FICRE. And we also have the defeat of the Chevron rule, which I'm sure it's coming up soon on these days. The Supreme Court is going to bring down the Chevron rule that gives deference, huge deference, to administrative agencies, and that's going to be substantially curtailed. So I believe that we are historically in a very good position to, for the Supreme Court to grant us, because if there is one important case that the Supreme Court in the entire century should look at, is this one. And it's not because it's our case. It's because it represents the obliteration of basic human rights of people that have been illegally placed on this list. And so I really hope that they will come through to the rescue and do their job. You mentioned, I want you to know that I will be filing that motion because I think it's important to set the record straight. And I think it's important for that motion to be there. We want to make sure that, in fact, all the judges of the Fifth Circuit saw the petition and decided against it, because I think it's a historic document. I was talking this week to a very Jesus Mendoza, who is a TI that has had many legal battles, and he's the one to tell me, that this case just set a historic precedent. It cannot be erased. And, I am absolutely certain this program is coming down. So this case will set for history who was on the right side of history and who was on the wrong side of history. And that's why it's so important.
Thank you, Anna. I agree. The word is spreading, and the legal community is talking about it. For example, there was a recent article in Wisconsin Law Journal that mentioned our case, among other revelations about the directed energy weapon. So, yes, there is an audience. There are people interested. The audience is getting wider. We are way past the fringe conspiratorial territory. We are entering the mainstream.
Let me just say that the Miami Herald demanded the pressure from Miami was so huge that the CDC is going to be reviewing their conclusions that there was no brain damage in the Havana syndrome victims. And this just came out last week. So it's like you say, pressure is mounting, and the dam will break.
Thank you, Anna. Richard, do you have any other questions for Anna?
Well, just a comment. Again, I want our folks that are members and in the TI community to understand that the court system is a slow process. It's not something that happens overnight. We think we've got a strong case. We built a strong group of plaintiffs as part of it. The Supreme Court is a final step, but keep in mind that we've got other things going as well. So we don't want folks to get discouraged. We want folks to continue to support our efforts, particularly through the conference calls. Keep calling in if you've got questions, and we'll try to get you some answers. But just understand it's a slow moving train. We wish it could, happen quicker, but we're doing our best to push these issues through and try to get a judgment in our favor. So we need folks to be patient and understand this is a slow process. We're doing the best we can.
Thank you, Richard. I hope that everybody understands that this is a marathon. It's not a sprint. And that's why we always need your support. It's a long process, but it's worth it because what's at stake is our freedom. This is pretty much it for our legal update, and I would like to ask for your final words and announcements. Anna, let's start with you.
Yeah, well, I just have one announcement, and it is that Harold Brems, a TI from Germany, look him up. Harold, Hareld, Brems, Brems. He did a short video, very nice video, and I think it's time for targeted individuals to come out of the closet and stop hiding behind, names that are not real, and go out and say, my name, and I'm going to do it today. I'm going to put on the makeup, and I'm going to do it today and put it out on Twitter, and I invite everybody to do it. My name is Ana Toledo. I am an attorney from Puerto Rico. I am a targeted individual, because unless people start seeing that this is real, that we're not, and don't go into, the brain hive, whatever. I don't even know those names because I don't even listen to that. But, just be real. And that I think that is one good thing that you can do today to end your targeting. make people aware that this is not fantastical. Len?
That's a good advice. I agree. If you're going to speak about your targeting, speak about things that you know that you confidently can support, and you don't have to explain everything because we don't know everything. So when people ask you for an explanation, the answer "I don't know" is a legitimate answer. Be yourself. Talk about things that you do know. Richard, for your final words, please.
Thank you, Len. So, again, I wanted to emphasize, I know folks out there have questions. Our conference calls during the week, we've got Gaji, Devin, Melody, and Helen in Australia. We encourage you to join those shows, express your comments and concerns, and if you've got questions, we'll try to get you some answers. As you know, we're at tjustice2@proton.me. You can contact us that way, and we'll try to help as quickly as we can. So thank you for sharing some time, Len. Thank you.
So you are looking at the core team of Targeted Justice. You can see how committed we are, how regardless of what the Fifth Court decided, we're celebrating this as a victory because this is the first hit against the glass ceiling of the Supreme Court. These important questions that Anna listed are reaching the Supreme Court for the first time. And that is a reason for celebration. That is progress. Thank you for watching. Until next time.